I did never on her property. I never crossed the tree line. I just wanted to tell her that Alana was fine and living with my middle daughter in Elko, Nevada. That's all I wanted to say to her. And she
Okay.
started coming towards me
Okay.
with a spade.
Is Karen Hollinger either at the security station or on Zoom? There we go. Ma'am, I am super sorry. I am Judge Satterfield. Trust me, I am. I know you can't see me. But
Okay.
I have an old iPad and my computer
I can
died.
see you.
And
I can
so
see you now. I can
it's
see
sitting
you.
somewhere where you can't see me, and I apologize for
I can
that.
see. I can see you, ma'am.
Okay, very good. All right. Um, I guess you are here on a case number 25 CR 440. Is that right? And you posted a
Yes.
bond already in the amount, a cash bond in the amount of $3,000,
Yes, ma'am.
which I will approve today. And as long as you appear at every single hearing that you're ordered to appear at the end of your case, when you're no longer required to appear, you will get all of your money back.
Ma'am, I want to plead guilty.
Well, hang on just a minute.
Okay. I just want this behind me. I want it over with.
Okay, let me look here.
Okay.
Before we even get into the courtroom chaos, listen closely to what she's saying. A 64-year-old woman claims she never stepped on the property. She says she stayed beyond the tree line. She says she only wanted to deliver a message about a child being safe in Elko, Nevada. And yet here she is, bonded out for $3,000, facing a criminal case, and begging to plead guilty just to make it stop. So what really happened here? Was this a simple misunderstanding that spiraled out of control? Did law enforcement overreact? Or did a missed court date turn a manageable situation into a full-blown warrant and arrest? Because here's where it gets complicated. She claims she wasn't told about a restraining order. She says she applied for diversion and thought the case would be dismissed. Then she fractures her skull, pelvis, and ribs, and deputies arrest her while she can barely walk.
Who is Deborah Hollinger?
He is or is my husband's adopted cousin.
Okay.
I never stepped foot on her property.
Okay, at 105 North Chestnut and
Yes, and I haven't been back there. I just wanted to tell her that we had this adopted daughter that she's actually our oldest granddaughter, and she she lied to the deputy that was in charge of Douglas High School, and I was not told I had a restraining order. I was not told I had a no trespassing order. I was not told that
Did
when I signed up online for that, what do you call it?
Okay.
Diversion. So I don't know while I'm here.
Right away, notice something subtle but important. The judge sets a calm, apologetic tone. Technical issues happen. But that human moment matters. It lowers tension. It shows this isn't a hostile courtroom, at least not yet. But underneath that politeness is something serious. This is a bond review on a criminal case. She's already been arrested once for failing to appear. The judge is about to clarify what went wrong. And sometimes in these hearings, the biggest problem isn't the original allegation, it's misunderstanding the process. When courts say, apply for diversion, that does not mean the case disappears automatically. And this is where a lot of defendants get trapped, assuming paperwork equals dismissal. Let's see how this unfolds.
Okay, did the sheriff's office,
Yes,
come
they
to her
arrested.
address while you were there?
No,
Back on the 12th day of September in 2025?
no.
Okay. Well, you had a first appearance September 24th.
Yes, and the court clerk suggested I do the diversion. And they said that we would be notified by mail if it was accepted or denied. And we were never notified. So I thought, because I was told that we did this online, that sorry, I'm sorry, it would be dismissed. And then I fell down right before Christmas. I fell down the stairs. I fractured my skull in 2 places, fractured my pelvis, broke a rib and fractured a rib, and they came and picked me up and took me to jail. I could barely walk. And if you have the pictures of the first arrest, which you should have, and the picture of my profile or my face in the second arrest, you can tell that they made me walk downstairs to the basement, and they stayed in the basement, and they watched me undress and get dressed. And then they walked back.
That right there should raise a red flag. Why would someone who just claimed they never crossed the property line immediately want to plead guilty? This isn't someone confessing out of remorse. This sounds like someone exhausted. Someone scared of being arrested again. Someone who thinks pleading guilty is the fastest way to make it stop. But here's the legal reality. Pleading guilty means accepting consequences, fines, probation, maybe even jail, and possibly admitting to something you insist you didn't do. The judge recognizes the contradiction instantly. This is about to become less about trespassing and more about whether this defendant understands what she's giving up.
I got up the stairs and I could barely walk. This is not right. I did never on her property. I never crossed the tree line. I just want to tell her that Alana was fine and living with my middle daughter in Elko, Nevada. That's all I wanted to say to her. And she started coming towards me with a spade and mud.
I can tell this is very upsetting for you, and I understand. But
I'm just going to plead
I haven't been a
guilty.
part of anything else, so I can't swear to any of it. But usually what happens is that when you appear and you looks like it's something you could apply for diversion if you wanted to, they suggest that you inquire and that you do that, but they also give you a court date, which means if you haven't got any notification that you've
I should have appeared. So failure
to
appear, and I am guilty.
Okay.
I am guilty.
So that's what got you arrested, is not being at the courthouse on 12/15 of 25 at 9 o'clock. So that's what got you arrested subsequently.
I understand
that you posted this bond on December 29th.
I understand,
Okay.
ma'am.
So, are you retired?
I will be soon. I'm 64 and 10 months, 5 months or something. I retire at the age of 65.
Okay.
I live at home. My husband works at home. I'm a housewife.
Okay. Well, I am happy to appoint an attorney to represent you, or you can hire one if there's one, but you need an attorney. Because it sounds like you need to go to trial with what you're explaining to me.
I know, but I just want to do my time.
But here's what's important. The arrest wasn't for the alleged trespass at that moment. It was for failing to appear in court. When you miss a court date, a warrant can automatically issue. And once that warrant exists, law enforcement is obligated to act on it. This is the collision between personal hardship and procedural law. The court system doesn't pause because someone is injured, unless there's formal documentation or a request to continue. That's harsh, but that's how it works. Still, you can hear how traumatic this felt to her. And emotionally, she's linking that arrest experience with the original charge. That's why she wants this over, not because she agrees she's guilty, but because she doesn't want to relive that fear.
I want to get it over and behind me. I can't do this again and wonder when the next time a sheriff's deputy is going to come to my house and arrest me. I just
Well-
want it behind me. So if you could give me my sentence,
Well,
I
but
will
you
sign the
plead no
paper.
contest or guilty. So,
I'm
and if you
guilty.
tell me you didn't do these things,
That's beside the point. I
well, not
just want
really.
Well, ma'am, Your Honor, I will be 65 years old on May 1st. I was born in 1961.
Yep, I was born in
I've been to
63,
jail.
so I know where you're coming from, sure.
Yeah, but the thing is that I've never been arrested. Well, one time I was arrested, but guess what? It was false identity. My sister used my name. And yes, I was arrested. Yes,
Okay.
but I was never charged.
All right, well, hang on just a minute. Mr. Sweeney, do you show any record that she submitted documents applying for a diversion?
I do, Your Honor. I see that we received her application, and then at least the notes in our prosecution system indicate that she was denied. And then she would have still been scheduled to appear on that control hearing on the 15th of December, and then subsequently, with her non-appearance, Judge Webster issued a warrant. And I guess also let me maybe add this to Your Honor, that even if
But here's where defendants sometimes blur lines. Admitting you missed court doesn't automatically resolve the underlying charge. And pleading guilty, just to move on, can have lasting consequences. The judge sees the confusion forming. You can almost feel the judge slowing things down, trying to prevent a rushed plea that could later be challenged. Courts don't want appeals based on, "I didn't understand." So this is where judicial responsibility kicks in.
we were to go ahead with a plea today, I would probably request a continuance to sentencing, considering that it's a victim offense. And as far as today's hearing, I don't know what was communicated to the victim regarding her ability and knowledge that there would be a sentencing today.
Well, first of all, if somebody pleads as charged, there's nothing a victim can do about that. Do they have a right to make a statement, or if they have restitution? Yes, I suppose so. But I can't stop her from pleading as charged. Can I continue her sentencing? Yes. Now, did you make note why she did not qualify for diversion? I mean, do you guys do that, or is it just pretty
Your Honor,
discretionary?
I've been looking for that in our system, and I'm guess I'm not seeing that. There's a lot of